We are going to be recording this, so I just wanted to let everybody know that. I see some familiar faces. Thank you so much for joining us today. We're going to get started in about 1 minute. Good evening, everyone, and welcome to tonight's webinar, Guardianship and Least Restrictive Options, sponsored by the ARC of Pikes Peak. My name is Pam Christie at Peak Parent Center, and I will be monitoring the chat throughout the training. I'm a parent of an adult daughter who has gone through this process about 6 years ago, so I'm so happy to have Christina here. And before we get started, I'd like to go over a few items so you know how to participate in today's event. You will be muted for most, if not all, of the presentation. Please use the chat at the bottom of your screen to ask questions throughout the training. Closed captioning is available at the bottom of your screen. And please select Spanish interpretation if needed, which is also at the bottom of our screen. Mirna, did you want to?
Sí, bienvenidos. La interpretación al español está disponible. Si desea, puede accesarla en el icono del mundo y escoger el idioma español. Si está utilizando este taller en su teléfono, puede accesarlo en los dos puntitos y deslizar hasta donde dice lenguaje o interpretación de lenguaje, y ahí encontrará la opción al español. Si tiene alguna pregunta, puede poner su pregunta en el chat y con gusto le puedo asistir. Gracias. Thank you, Pam.
Thank you. It is my pleasure to introduce our presenter, Cristina Butero from the ARC of Pikes Peak.
Thank you, Pam. I hope everyone's in the right place, supporting decision-making and guardianship and alternatives. If you're not, you're welcome to stay, but in case you jumped on the wrong webinar, that happens sometimes. I know I've done it before. So the one thing that always comes up when we are talking about what happens when someone turns 18, as far as decision making, is that we always go to the idea that people are going to be alone and that they're going to have to make decisions all by themselves. And that's just not the case, because that's not how we function as a society. So no one is ever truly independent or interdependent on one another. We all have a circle of support that we use when it is time for us to make decisions. And we automatically kind of step over that when we're looking at people with intellectual and developmental disabilities. And so we have to keep that in mind, that I don't make decisions by myself. I have a circle of support that helps me make decisions. You have a circle of support that helps you make decisions. It is very rare that people make decisions, big, major life decisions, all by themselves. They use lots of different tools. As Pam said, I'm Cristina Butero. I am with the ARC Pikes Peak region. I am the guardianship coordinator. I have been with the ARC nearly 14 years. I have worked in the field of intellectual and developmental disabilities in the Pikes Peak region for 26 years. So I've done a variety of things in the field. So very familiar with waivers and services and supports. And so separate from the guardianship piece, the ARC also provides advocacy, and that is a way we can support families. My contact information is listed here. We do have 2 staff members who are Spanish speakers and assist families through the guardianship decision-making process as well. And so their information is listed. A little bit about the ARC. Our mission is to promote and protect the human rights of people with intellectual and developmental disabilities and actively support their full inclusion and participation in the communities of the Pikes Peak region. Our vision is a community where all individuals with intellectual and developmental disabilities are respected and embraced. We hope to provide education to you tonight about decision-making. But also if there are questions about waivers and advocacy, we can also dive into that, or you can always email or call me with those questions. Our guiding principles at the ARC is to promote autonomy first and foremost. I know for me personally, that's the most important thing for me. It's my autonomy. It's my decision to make the choices I make without someone else interfering. We also promote self-determination. We work towards a person-centered world for individuals. We believe in dignity of risk. We've all had that opportunity to learn and grow from bad decisions. We safeguard the human and civil rights. And so part of the decision-making discussion will be about just that. We are looking at least restrictive interventions at every level, whether that's school or residential services or decision-making. Objectivity of the interested persons, and I hope to educate those who support people with intellectual and developmental disability. If the one thing you take away from today is that not all adults with IDD require a guardian, then I've done my job. So we'll go over some decision-making options, supported decision-making, alternatives to guardianship, and then we'll spend some time talking about the guardianship process itself, and there are a list of resources included in this presentation. So, we started off with talking about how we are all interdependent. But the other thing we need to also address, kind of the elephant in the room, is that we tend to protect people with IDD because we've had to. We've had to protect them, but sometimes that gets too tight. And so as people start to hit that magical age of 18, looking at what that means for them and opening up their world. And if we can do that at a much younger age, that's what's best, is starting to loosen some of those protections. But we have to acknowledge that's what we as a system have done for years and years and years, what schools have done for years and years and years. And so we have projected that onto families. And so we recognize that, and we want to help you to recognize what is fear versus real concern, and working through those personally for you and your family member. So some defining terms, because that can get confusing when you have all these terms coming at you around decision-making when you've only been told probably guardianship. So let's talk about what supported decision-making is versus substitute decision-making and best interest. Supported decision-making recognizes the individual autonomy of inherent dignity of a person with intellectual and developmental disabilities, respects the freedom of such a person to make their own choices, acknowledges the independence of persons with disabilities. It generally occurs when people with disabilities use friends, family members, and professionals to help them understand the everyday situations they face and choices they must make, allowing them to make their own decisions without the need for substitute decision maker. And we will get into what that looks like and how you implement that. Substitute decision making is making decisions for the person who is not able to make his or her own decisions. Guardianship is a substitute decision maker. And then best interest is considering the least intrusive, most normalizing, and least restrictive course of action possible to provide for the needs of the individual. So as we go through all of this, just keep all of that in mind, and we can refer back to it if needed. So decision-making supports. It is crucial to understand that at 18, a person with or without an intellectual disability is their own decision maker. That 18 is the age of majority in Colorado, and therefore a person becomes their own decision maker, whether they have a disability or not. And in order for someone to be a substitute decision maker, you have to go through the legal process of getting guardianship. You do not automatically step into a guardianship role for your loved one as they turn 18. So when you're hitting that and trying to decide, is guardianship appropriate for my loved one? Is it the best thing for them? Is it the best thing for me? You have to take a step back and look at what guardianship is and what it entails. And it's truly about decision making. And so when you're evaluating your loved one's capacity to make decisions, that's an important statement to know, capacity to make decisions. You need to consider what their skills are. And is it that they've never had experience in making decisions, so they don't know how to make a decision? Or is it that they truly lack capacity? And I apologize, my computer sounds like it's going to take off from my desk. So I hope you all aren't hearing that very loud fan. If you are, I'm sorry. So what types of decisions are needing to be made? If you look at what decisions need to be made for someone at 18, there really aren't a whole lot. As far as school and transition services, you are still considered that person's legal guardian under that system. So if decisions are based around that, you still have authority. So what decisions separate from school will that person be faced with? Have they ever made decisions like that before? Has the person been assisted to understand the risks and benefits through that decision-making process? How big is the impact of the decision in the person's life? How long would the person live with that decision? How hard would it be to undo a decision? Purple hair, it'll grow out, you can cut it out, you can dye it again. Tattoo, little different. However, those are not decisions that a guardian has any authority to make for their loved one. And the most important thing is, what is the least restrictive level of support that person might need? So for any of you that have ever worked with 18-year-olds, have your own child who is turning 18, there are very few 18-year-olds who make good decisions. That just doesn't happen. That's when people start to really learn how to make decisions. So with or without an intellectual disability, 18-year-olds don't make good decisions. I did not make good decisions at 18. I don't know that I made good decisions at 21. And I know at 48, I don't make good decisions every single day. But that is my right to do so. I have to live with those consequences. And how is it that I make those decisions? And so for someone who has an intellectual disability and maybe has not been included in a lot of decision making, you're going to see that they don't know how to make those decisions. You're going to see that they struggle with taking in information and figuring out how to process it and how do they come up with, you know, the risks and benefits if they've never had the opportunity to do so. So we have to take that into account when you're looking at decision making and a person's capacity to make decisions. Take into account their age. Again, 18-year-olds don't make good decisions, period. I don't have to put anything else with that statement. Just 18-year-olds don't make good decisions, period. Can you wait a year? Is it a situation where you don't need to do guardianship right away, but you can look at what is the next year going to be like for my loved one? Can I teach them how to make decisions in this year? And if the first year up until 19 goes well, give it another year. You can petition for guardianship any point after the age of 18. And we at the ARC have a robust guardianship program. We have 74 individuals that we are the legal guardian for. And many of those individuals, we've not stepped in as legal guardian until they were a little older. So it doesn't have to be right at 18. And we'll talk about those alternatives, those safeguards. So you can look at this at any point. So give it some time, see how it goes, explore some of the alternatives, because you will be asked that in a guardianship hearing. You'll be asked, what alternatives have you tried? And practice. Have your loved one practice those decisions, because again, it is very difficult to know what to do if you've never had to do it before. And so in the arena of practicing, talking through decisions and asking questions about what they might do or what might happen next. What will you do in this situation? What do you see as being the next step? Where would you begin? Who would you go to if you needed assistance with something? You know, really honing in on what is the decision? How do they make that decision? How would you yourself make that decision? Engaging them in that process with you so that they are having that opportunity to learn and grow and practice and develop those skills. For those of you who have loved ones that are under the age of 18, you know, the 15, 16-year-olds, now is an excellent time to start that. For any parents who have 5, 6-year-olds, now is an excellent time to start that. Really, decision-making should start at a very young age and only giving them what they can handle, right? You don't want to overwhelm someone. You don't want to make them get discouraged if decisions that they make aren't always the best decision, but give some leeway, start to practice. The 15, 16, 17-year-olds, it's a great time to help them look at their circle of support and implement some of the supported decision-making tools that I will show you here in a bit. Own your advice as your own opinion and recommend seeking others' opinions, which is hard to do sometimes, especially as a parent. You know, telling your son or daughter, this is how I feel, this is what I feel, this is what I want for you, isn't always easy, but that's going to be very important so that they recognize that they can have an idea, an opinion, a decision that's different from yours, that's separate from you. Encourage the pros and cons list. However it is they would do that. If it's written, if it's verbal, if it's looking at pictures, helping them to develop what it is that they will use to help them develop a pros and cons list. I remember one of my classmates would always draw pictures to help him to study, because that's what he was, very visual, and that's what helped him to study. And so if that's what someone needs to doodle, to draw pictures, it's what is going to best support them. Offer the opportunity for role playing as ways to participate in decision making. A great way to do that. I'm not a big fan of reality TV. I don't watch a lot of it, but I know that it's very popular. Watch some reality TV with your loved one and look at some of the decisions that are made on reality TV, and then use them, talk through some of that. Are they far-fetched? Sometimes, absolutely, but they're a great way to start the conversation, and then practice it daily. Practice those decision-making opportunities daily. Self-advocacy is always encouraged and supported. We don't do enough of it in school. I know Peak is very much a proponent of people being involved in their IEPs, running their IEPs. Have your loved one do that if they're not already doing it. That is so important with self-advocacy. If they have a doctor's appointment and they're at the age where they can start thinking about that, have them write down questions that they can then take into the doctor themselves to ask those questions. Create an environment of independence, not dependence. So, while I talked about in the beginning that we're all interdependent, but it's in an independent environment, right? So don't create a situation where your loved one is dependent on you for everything. This is the part of my training where I usually get some tears, so I apologize ahead of time, but there's a good chance that you're not always going to be there. And it's part of that future planning that you have to think about. If I'm not here to make this decision for my loved one, who's going to do it for them? Will someone do it? Or is it better to give them the skills and the tools to be able to do it themselves, or to have that circle of support to help them with that? You don't want to create a situation where you have been the only person doing that for your loved one, because then if you are not there, what happens? And to me, that's much scarier than a person's opportunity to actually make a decision and fail with you there as a safety net.
Christina, we have one quick question, if you don't mind interrupting
Sure.
you.
Absolutely.
Thank you, Richard. I thought medical and financial guardianship had to be completed by age 18.
No, you actually cannot take on guardianship until after the age of 18, because you are still considered guardian prior to 18 as parent, or as if you're in a legal guardianship situation for a minor, you are already that. You cannot have a hearing for an adult guardianship until the person is 18 or older. I hope that clarifies for you, Richard. Okay, talked about self-advocacy. Okay, encourage problem-solving techniques. That's going to be important no matter what, whether it's decision-making or any adulting situation. Encouraging those problem-solving techniques is just going to help the person to be successful. Okay. So, as I said, everyone needs supports when they are making decisions. And sometimes it's as simple as, what are you going to have for lunch today? We did this today in my office. It was perfect timing. Nobody brought their lunch. So, what do we want for lunch today? And we went through the whole supported decision of what we were going to get for lunch. While that's a silly example, that is the perfect example of supported decision-making in its very basic nature. There were 3 of us that were going to order lunch, needing to figure out what we were going to have. We talked through it. We looked at what did we have yesterday? What are we having, people having for dinner? And so it was truly a great way to practice supported decision-making. When people are given the opportunity to make a decision and that decision does not turn out right, then you have to also have the conversation about that failure and talk through why it wasn't successful. that is as important in this whole process than anything else. So learning from those failures. And it may take someone 3 or 4 or 5 or 10 times before they start to get the hang of it. But it's that practicing, it's that discussion, it's that dedication to giving them opportunity to expand that knowledge, to learn from those mistakes. So for about 8 years now, the Pikes Peak region has been talking about supported decision-making philosophically. There have been other states that had legislation to for supported decision-making as an alternative to guardianship. We did not have one until recently. And so for this, I just took a snippet of what the bill is, but there's an actual, I'm going to get out of this so I can show you that. Are you able to see that? It says an act. So this is the legislation in Colorado that actually looks at, recognizes, and supports people having the opportunity for supported decision-making as an alternative to guardianship. This is such an important piece of legislation for the people that we love and support, because it allows them the opportunity to keep that autonomy and to decide who's going to help them make decisions. It really is probably the most important legislation that we've seen in a long while for people with intellectual and developmental disabilities. And supported decision-making is also used in other types of guardianship. I just know it specifically for people with IDD, but you'll start to hear it more and more. You'll hear it now with lawyers, if you're engaged with any lawyers in our community or in the Denver metro area. I think many of you are from the Denver metro area. It's really being pushed now to look at. The courts are pushing it now to look at. Even court visitors are really talking about this as a potential least restrictive alternative to that guardianship. And so we can, if anyone is interested in actually receiving a copy of this, we can get that to you. I just wanted to show it to you so that you could see that it's now in law. So get to the slides now. Oh, sorry about that. So putting supported decision-making into practice. The beautiful thing about supported decision-making is that it really recognizes a person's abilities and it builds upon them. And that's the important thing, is to recognize what is your loved one good at, and building upon that to develop a good supported decision-making plan. Opening up that circle of support. It may not be you who is going to be the supporter in a supported decision-making plan. It may be that your son or daughter, loved one, would like to have a sibling help them make one particular decision, or a best friend, or I'm Tia to my nieces and nephew, and Tia would be the one to help make some decisions for them. So it's really looking at who is in their circle of support and them deciding who is going to be that person to help them make a decision. Provide education to the supporters about the decision-making process. Now, this is brand new to people, especially if you've never heard about it before. And so it's going to take some education. It's going to take providing some resources for those people that have been selected as a supporter, so that they understand that their role is not to make the decision for the person. Their role is to offer guidance, is to offer support in figuring out what information is needed to make a good decision, looking at providing guidance, having them gather information, and then helping them to communicate what that decision is. It is never to make the decision for the person. It's never to influence the person's decision. Okay, let's see, I'm sorry. Now I'm going to get back out and show you an actual. I couldn't embed these in the PowerPoint, so I apologize for jumping back and forth. The Arc of Colorado developed this tool. Let's see if I can get it bigger. That is a supported decision-making agreement. And it walks through each step of putting an agreement into place. And then it also offers an actual written agreement so that you can go through this with your loved one. Very easy to follow, very easy to fill out. And there are also other tools that are available for developing a supported decision-making agreement. And this too, if someone would like this, we can absolutely get this out to you all, or it can be found at the Arc of Colorado's website. And so this is their web, thearcofcolorado.org. Just click on the supported decision-making tab, and then they have all these great resources for supported decision-making. There are incredible resources. Let's see if this opens up on this website. I use this website all the time to look for resources around supported decision making when I get questions that come up regarding it. The other links on this website are phenomenal. The National Resource Center for Supported Decision Making will show you what other states have in place. We work with a lot of families who are connected with the military, and that we get lots of questions about what does other state, what will another state recognize? And so this is a great tool and resource for you if you're looking at supported decision making. Guardianship's a little different beast that we'll get into here in a bit. So are there any questions as of now to supported decision making? I'm going through this really fast because I'm trying to get it all in within.
I didn't see any questions yet. They have asked for the PowerPoint to be sent out, which I will do tomorrow.
Okay. Fantastic. Okay, we will jump into alternatives to guardianship at this point. Supported decision making is the most obvious alternative to guardianship, but there are some other alternatives that can help give you a little peace of mind versus just not having that safety net. Oh, I'm sorry. Now let me go back here. Power of attorneys can be used as long as the person understands what that means. Do they need to be able to read a legal document written by an attorney for a power of attorney? No. because there are great resources for powers of attorney that a person can understand. They just need to understand that it is their power that they are giving to you and that they have every right to take that power back. I always encourage, if you're going to do a medical power of attorney, that you look at it being a durable medical power of attorney, because a durable medical power of attorney stays in place should someone lose capacity. So if there is an accident or an illness, the person cannot be engaged or involved in a decision, that durable power of attorney stays in place. If it's a regular power of attorney, that power of attorney ends when the person becomes incapacitated. So that's going to be very important to distinguish. If you're interested in a power of attorney, I've got a great document that I can send to you for that. The other power of attorney that could be used in these situations is what's called a springing power of attorney. We see this a lot with military members. A husband or wife will fill out a springing power of attorney that their husband or wife has authority should this or this happen. That's not as commonly used for people with intellectual or developmental disabilities, but it is absolutely an option. We always tell families that if you are going to do a power of attorney, while it's not needed to be signed in front of a notary, we recommend it just so that there's those second set of eyes that sees that a person is not being coerced. Because sometimes that happens with power of attorneys. For a financial power of attorney, that does need to be notarized. If it's the possibility of having two separate powers of attorney, if you're looking at this, so a medical and a financial, that's best practice. But sometimes we know that's not an option. For medical proxy, that is authority, decision-making authority, when someone is not able to make their own medical decisions due to an accident or an illness. So there's nothing in place. There's not a living will. There's not a most form. There's no advance directives in place. Someone has a sudden illness or accident, then family, friends gather, decide who's going to make those medical decisions. That's communicated to the doctor. And then that person is the decision maker for that occurrence. There's not a form, there's not a document. Typically it's just either a letter to the doctor or a doctor will make a note in a chart, but it's for that specific occurrence. It's not something that's ongoing. So if it's a situation where someone is injured, has a brain injury, loses capacity to make decisions, for the initial medical necessity for decision making, you could do a medical proxy and then you would look at what comes next. Is it a guardianship? Is it something else? Other medical decision opportunities are advance directives, just writing down what it is you want. If you all don't have your own advance directives done, I encourage you to do so for yourself so that people know what it is that you want or don't want. Here at the ARC, even though we are the legal guardian and the medical decision maker, we have that power and that authority, we complete a most form. It's a medical order scope of treatment for individuals that we support, because that then is with them all the time. And they can go into, if they go into a hospital, the doctors can look and say, okay, they don't want compressions, but they do want nutrition or whatever the case may be for that person. That's really important to have no matter what, because you're not always going to be with the person.
May I ask a question?
Absolutely.
Hi, this is Millie, and I work with Spanish-speaking families. So one common thing that I noticed is that they seek guardianship because of medical reasons. Like they take their children to the doctor and they
have turned 18 already, and the doctors won't give them information, or will just take they will take the person with the disability inside the room, and they will not allow the parents to join and things like that. Like, what would be the best approach to, because I feel like seeking guardianship for that reason is like, why go through the whole, it's like too much trouble for something, that could be achieved in a different way. Like, I know that you explained about the durable power of attorney.
Yes.
Can you touch a little bit more on that, or maybe give me more guidance on that area, or how to go about it? Because of let's think of an IQ of 70 or below 60, right? And that they might say, oh, this person is not able to provide the power. I don't know. I don't know what would be the barriers to like getting a powers of attorney, and do the families need an attorney to develop a durable power of attorney letter, or like all of that? Sorry, that's a long one.
No, that's fine. You do not need an attorney for any of this. And that's why we do these kind of workshops, so that families don't feel like they need to go to an attorney. I have a form, and we have someone who can translate the form for a medical power of durable power of attorney that's easy to understand, because that's part of the problem. When you get an attorney involved, you get all legalese. I hope there aren't any attorneys on here. There are. I apologize if I offend you. But it's the legalese, and we get caught up in what does this mean, and overwhelmed with all of those words. It doesn't need to be that hard. And so the form, the durable power of attorney form that we have, explains how to pick someone to help make medical decisions and give that power of attorney, and what it means to do that. And then it's a very simple form to complete. Sometimes I have seen those power of attorney forms be 4, 5, 6 pages long, and it's just not necessary. It's not needed. But an alternative to a power of attorney is just getting consent for, get the doctor's office getting consent from that young adult for parent to attend that medical appointment, or parent to get that medical information. There's, doctors' offices are always very concerned about HIPAA, as they should be concerned about HIPAA, but signing a HIPAA release form sometimes is enough. Just knowing that the person gives the doctor's office permission to speak with a parent is all that's needed. And so it's really case by case, and looking at, can my son or daughter sign this consent form? Do they understand what it means? And if they do, that should be enough. Now, if there needs to be decisions made that the person is going to need someone to make decisions for them, that's then when you're looking at a power of attorney, or then that next step of a medical guardianship. But if it's just because a parent wants to be involved in those appointments, in those conversations, all it is giving consent for them to be involved.
So, okay, I work more with like examples, and to understand better, would you say that like sometimes the person with a disability needs oral surgery, or for their, to pull their a tooth or something like that? So that would be where they would need a power of attorney, right? Letter, a durable power of attorney, or can they just give consent for the parent to help make that decision?
So they can just give consent for the parent to help make that decision. If that is needed, that decision should not have to be made in 1 or 2 days. So, if they go into the dentist says you need to pull this tooth, that decision should not have to be made in haste. Nobody makes good decisions in haste. And so taking a step back, having parent in the room to be able to explain why that decision needs to be made, why the tooth needs to be pulled. And if then the young adult can give the consent to pull the tooth, then all that's needed is consent. If the young adult can't give that decision to pull the tooth because they're in too much pain, or, you know, whatever the case may be, then it's maybe looking at a power of attorney. So it's really case by case. And I know that's frustrating, but it truly is looking at each individual situation, and nobody has to make those decisions in haste. Medical providers have to follow ethical practices. And if there's an emergency, they have to treat, unless there is an advance directive that says otherwise. They have to treat that person. And so they're going to treat, and then they'll, you know, follow up step. That's where decisions will need to be made. But in those emergent situations, they have to treat. Otherwise, those decisions can be rightfully vetted and looked at, and second opinions, helping make those decisions. Part of, you know, dental is a great example. Some people just fear going to the dentist. I do. I hate going to the dentist. I fear it. So what can be done ahead of time to help me through that? And I can guarantee nobody's going to pull a tooth if I tell them not to. If I don't want that done, I'm going to fight it. And so then it's also educating your young adult about why it needs to be done. Helping them to understand why it needs to be done, helping them to work through the fear, helping them to figure out, does something, you know, do they need something ahead of time, something to help with the anxiety ahead of time before going to the dentist. So it really is situational, and looking at what decision absolutely has to be made in that moment. I hope that helps, Millie.
It does. I just feel that there is probably lack of understanding from the medical providers that the person with the disability can make their own decisions, and they don't need to go any further as to, you know, sometimes they have to sign, and they're like, well, if he's not understanding what he needs to sign, then you need to get guardianship. And that's the first thing out of their mouth.
Yes.
And, you know, that, like, how I would like a good answer, a good comeback from the parents to inform them that that's not the only route.
So a parent needs to ask, what have you said to them? And can you explain it differently? Can we get other information in here to explain it so that they can understand it? Because I think we've all probably been in situations with medical providers that we don't understand sometimes what they're telling us. What are you saying? Why are you saying it? How are you saying it? So making sure that all avenues of providing that information to the young adult have been tried, that it's been explained in a way that they understand. I have a friend who I used to do this training with when she worked at the Resource Exchange. She was legal guardian for her brother, and he had some cancer that needed to be removed from his gallbladder. And so she explained it by using a tomato, and how, you know, this part of the tomato is rotten. You know, they want to take this out. And so really getting down to what makes sense to that person is where we have to go with explaining information so that they can make an informed decision. And that's, you know, really where the parent and the young adult has to advocate for themselves too. You know, they have to advocate, no, I want my mom or dad in here, or please explain this differently to me. I don't understand what this means. So really that encouragement of self-advocacy as well. So we talked about consent. That's for anything, you know, right? Signing consent to talk to a direct service provider, or to talk to a community center board or single entry point. As long as the person is giving consent, then that is allowed. Yes, Cindy. Oh, she's on mute.
Cindy, can you unmute yourself? I see you
Unmute.
raised your hand. There you go. Thank you.
Thank you so much. He's intelligent. He's 23, and sometimes though I can see that there might be a case when he would refuse treatment, like having a tooth pulled. And I won't go into all the reasons, but what would we do in that case if it was something that needed to be done but he refused?
Well, even as legal guardian, he has the right to refuse. Because
Okay.
I mean, are you going to force him to sit in the chair?
Well, you can't, obviously, but I'm
Right,
thinking
right.
if it's going to get infected or, you know.
Well, and so that's then looking at what can be done to help ease that anxiety to get him in the dental chair. And so it's all that work ahead of time. You know, can we give him something to help him with that? Is it a situation where maybe it's sedated dentistry? You know, and is he willing to do that? Part of the whole guardianship idea, and we see it all the time, is that people think it's the end all be all, and it's really not. We can't force people to do things, because then it becomes a situation of even potentially physical abuse for that. And so it's that heavy front end working on how can we make this work? What do we do? If it becomes an emergent situation, you know, that he goes to the emergency room, you know, how are they going to treat it? Do they give him something to sedate him? So it's, how can you do that without having it become that emergent and not having that fight, that conflict?
Okay.
It may take trying lots of different things.
Oh, it would be lots.
Yeah. And being creative and, you know, pulling in other people maybe, or, you know, maybe it's, does someone else need to have a tooth pulled and he's going in with them so that, you know, they're doing it together? I don't know, just being creative and thinking about it ahead of time. But because even with a guardianship, you cannot force him to do that. A good medical doctor won't force him to do that.
Okay. All right. Thank you. Yeah, I guess that's just a concern. I'm living with them for about a year. And what I've seen is just this stubbornness to take any advice on anything. And it's so frustrating because it's harmful to him not to take the advice.
Well, and so it's figuring out how does it become his, that he is making the decision, that it's his idea.
Okay, his idea, that would be good.
Yeah. Well, and
Okay.
I'm going to be a little inappropriate here, but there's always that person in your life that, you know, just isn't going to do anything, and that's unless it's their decision. Typically around here in my office, it's the men in the office, unless it's their decision. It's one, so helping them to make that decision for themselves. You know,
Okay.
it's kind of working around that and figuring out what it is to get him to that point. And it's going to be,
Okay. Thank you so much.
fortunately.
Thank you. I'm not sure if I know how to get off of here now.
There you go. Authorized representative, I'll go through this real quick. That is for individuals who have Medicaid or Medicaid waiver. You can be their authorized representative, help them make decisions regarding their Medicaid waivers without having to be legal guardian. And it's them, again, being able to say, yes, I want you to be that authorized representative for me. Representative payee is huge. For individuals who are receiving Medicaid, either medical insurance or waivers, they can't have a whole lot of money. So they don't have assets. They don't have an estate. So there's not really a need for a financial power of attorney if the only income they have is Social Security. Because under Social Security, you can be the representative payee and have all legal authority regarding the decisions about that money without having to become the legal guardian. Again, the person has to sign that you can be the representative payee, or Social Security determines that they're unable to make those decisions for themselves. So then they engage a representative payee. But when you apply for Social Security, you're telling them, this is how I'm spending the money. You tell them how you're going to do it. So there's really not a whole lot of decisions that need to be made. Now, what we get quite often is, what if they get a credit card? Or what if they get a cell phone contract? Well, there's not a whole lot that can be done even up front if you're the legal guardian, because that all can be done online, kiosk at the mall. They don't ask in those applications, do you have a legal guardian? So you have some recourse on the back end as a representative payee to say, they don't have money to pay this. So you did not do your due diligence as a cell phone company or as a credit card company to look at what their income is. And so there's not much you can do on the front end. It's really on the back end that you can help in those situations. Advocacy is another great tool. The ARC provides advocacy for adults. We help to make sure that their voice is heard, that they're being respected, that their rights are being protected, that they are getting what they need, and sometimes getting what they want. And so just having an advocate sometimes is a good safety net for the person. We can act in a supported decision-making role for that person, or we can just be that second set of eyes, that person that someone calls when they're needing to make decisions. The gentleman that I gave you your contact information, Danny, he has worked with the ARC for, he just had his 10th anniversary. He has many individuals that he's worked with over the last 10 years that, call him on a regular basis. Danny, what do you think I should do about this? Danny, help me with this decision. So it's just, again, that second set of eyes, of ears, of support in that way. And then for people who do have estates, you can look at a conservatorship, but that's not typically what we see. It's again for people who don't have Medicaid, who do have large assets, that you can become a conservator, which is like a legal guardian. All right. So guardianship. Let's see how I'm doing on time. Oh, so sorry, that took a lot more time than I thought. The role of a guardian is to help a person decide where they're going to live, what supports they can engage in. So helping them to enroll in services and supports, getting them connected to Social Security, housing, other resources in the community that can help them be successful, medical treatments, and then financial decisions. That's what the authority of a legal guardian is. Then you're looking out for the person's best interest. But you as a legal guardian have no authority to make any other decisions. You can't decide if someone's going to vote. You can't decide if someone's going to drive. You can't decide if someone is capable of balancing a checkbook, choosing friends, dating, having sex, getting a tattoo. Legal guardian has no authority to make those decisions. Now, you as a parent have that parental role in helping them to make that decision, but you have no legal authority as a guardian to make any of those decisions for your loved one. You can't put rules in place. You can't put bright suspensions in place. That's not what a legal guardian's role in Colorado is about. So you can petition prior to a person's 18th birthday, but again, you can't have that hearing until after the 18th birthday. We tell families not to even look at the process until 3 months prior to the 18th birthday. The paperwork is really easy to complete. Seems like it would be very daunting, overwhelming, because it's legal documents. It's not. It's very easy to complete. The ARC here in the Pikes Peak region, we have a packet that we sell. You can go to our website. It has all of the documents you need to file a petition for guardianship, as well as samples on how to complete the documents, information about guardianship and everything that you need to do as a guardian. It has other resources. It's $40. It also gets you a membership to the ARC. We mail that to you. So if you go online, purchase it through our website, you're not going to download it because it's too big of a packet to do so. We mail that to you. You do not need an attorney to petition for guardianship in a pro se situation. So you can file the documents with the court, and then there is a hearing. So the court is going to ask about those lesser restricted alternatives to guardianship. And so having tried those before you actually petition for guardianship is going to be really important. Now, we know that there are individuals who truly need legal guardians. We have 74 individuals that we are the legal guardian for. We get that. You know, really what we try to encourage is that you not do that first before trying some of the alternatives. For guardianship, you are going to petition for guardianship in the county that the person lives in. So for those of you that live in El Paso County, you're going to petition for guardianship at the El Paso County Combined Courts on Tejon Street. If you are in Teller County, while that's still the 4th Judicial District, you will petition for guardianship in Cripple Creek. For those of you that live outside of the El Paso County, Teller County region, you're going to petition for guardianship in your county. You can go to the court's website that's listed down below, and you can put in your county to figure out where it is you go. My knowledge and expertise is in El Paso County. I do know that El Paso County requires things that other counties waive for parents who are petitioning for guardianship, like the criminal background check and the credit report. The courts are now requiring a CAPS check. That's for everyone. That is statewide. You'll have to do the Colorado Adult Protective Services check. But the criminal and background check, the criminal background check and the credit report can be waived in other areas. El Paso County does not waive them. There are filing fees. It's $199 to file. Then there are fees associated with the court visitor. That can be up to $500. Part of what is in our packet are the forms needed to request that those fees be reduced or waived completely. I cannot tell you what the court looks at when they do that because we're not involved in that process. It is very individualized. When you take the paperwork to file, then those documents are sent to the financial office to be reviewed and to determine whether or not those fees can be waived or reduced. There are, could potentially be fees if either your loved one is contesting the guardianship, which they have every right to do, or if it is a situation where parents are divorced and each want to be sole guardian, and there's a guardian ad litem needs to be assigned in the case so that that guardian ad litem looks at best interest. There may be fees attached to that. The court will decide how they're going to assess that, whether or not the state's going to pay for it, the court's going to pay for it, or if the parties involved will have to pay for it. When you complete, so if you do the ARCS packet, you complete the first phase of the packet, you you submit that to the court. After that, a court visitor is assigned. The court visitor is responsible for going out and meeting with you, meeting your loved one to determine whether or not guardianship is appropriate. If you are the appropriate guardian, they're gathering information for the court to make their final decision. They do a report to the magistrate. Once that report goes to the magistrate, you set up a time to call to get a hearing date. It is an in-person hearing. You can request that those hearings be done now WebEx, but for the most part, they're doing those hearings now in person in El Paso County. Other counties may be different. The person has to attend that hearing because it is about them. It is a process of legally stripping them of their rights to make decisions. And so the magistrate or the judge wants to interact with the person to make sure that the person understands that and that it's appropriate. And if you don't want to purchase the packet from the ARC, you can go to the court's website. They have a self-help tab. That self-help tab drops down. You go to Guardianship and Conservatorship, and then you get the instructions and all of the documents from that self-help tab. We do have some of the forms that have been translated for Spanish speakers. And so that is available. And we also have the 2 advocacy folks that will help families with the guardianship process. And they are also Spanish speakers, so they can help for those who need that support as well. Once the hearing is held, then you are responsible 60 to 90 days out to send the court an initial care plan. And then every year you have to report to the court. You have to do a written document that talks about how the person's doing, what's happened over the last year, what are the plans moving forward. And the court is very, Paso County anyway, they are very tight on those deadlines. It's typically around the person's birthday. And if you don't have it in by the person's birthday, about 2 to 3 weeks after that, you're getting a letter from the court saying you need to get this in within 30 days. If you still don't turn it in, then there's a hearing. I have seen cases where a bench warrant has been issued because the legal guardian did not show up for the hearing. I have seen guardianship stripped because the legal guardian was not submitting those court reports on a regular basis. And once you do one, you'll get used to doing them. Now, the reason why we tell families to not even look at stuff before 3 months prior to when you want to file is because the court will change the forms at any time. And we don't always know that they've changed them. So if you purchase my packet today and you're not going to file for guardianship until next October or until October, November, December, those forms may change and we don't know they've changed. So you have a packet that's not complete. You take that to the courthouse and they're going to make you fill the information out on the new form. So that's why we tell families to wait because we never know when it's going to change. We have someone who monitors the court's website on a monthly basis to ensure that we have the most recent documents, but we don't always catch it. So just make sure that you have the most current documents. Okay, we talked about the hearings. So some of the questions we get are around mental health and guardianship for people who don't have an intellectual disability, but they have a mental health disability. Those petitions are filed through the county. And so this is the telephone number for that. Because if someone is stable on their medications, they may have capacity to make decisions. And so it's a matter of getting them stable on their medications, maybe. So it's not the full-blown guardianship that you would see for a person with an intellectual disability or someone who is aging and losing capacity due to a neurological situation. And so finally, a whole bunch of resources. You have my information as well. I know that I am over on time a little bit, and I apologize for that. Are there any other questions right now?
I don't see any right now. And if anyone has any additional questions, please contact Christina or any parent advisor at Peak. And thank you so much, Christina, for this wonderful presentation. You will all be receiving the PowerPoint probably tomorrow. And just so you know, Peak does send out an automatic evaluation. And if you could please take a few minutes to complete that and provide your feedback as we strive to improve Peak services. If you have any other questions, like I said, here is Christina's information. You can contact any parent advisor at Peak. We also have a parent advisor that speaks Spanish. It's parent advisor at peakparent.org, 719-531-9400, www.peakparent.org. And again, thank you so much, the ARC of Pikes Peak. Thank you all for being on, and we hope you have a wonderful evening. Please check out Peak's website for upcoming webinars and trainings, along with the ARC of Pikes Peak website for their upcoming events and trainings. Thank you all so much, and have a great evening.